I would now like to introduce Professor Adam Candeub. Adam Candeub is Professor of Law and Director of the Intellectual Property, Information, and Communications Law Program at the Michigan State University College of Law. Professor Candeub has had a distinguished legal career, serving as a law clerk to a judge on the U.S. Court of Appeals for the Ninth Circuit, an advisor at the FCC, an attorney at prominent law firms, and in 2004, he joined the law school faculty. And Professor Candeub, if we have one thing in common, it was that I also served as article editor of my law review. From his faculty bio, Professor Candeub's scholarly interests focus on the law and regulation of communications, internet, and technology. He joined the Trump administration in 2019 as Deputy Assistant Secretary of Commerce for Telecommunications and Information, and he assumed the role of Acting Assistant Secretary. He later joined the Department of Justice as Deputy Associate Attorney General. Professor Candeub is also a Senior Fellow at the DC-based Center of Renewing America. Please help me in welcoming Professor Adam Candeub.
So the phrase disruptive internet technology has become a bit of a cliche, but certainly one technology in particular, I would say social media, has been disruptive of something of significance to most people in this room. Namely, I think social media has been disruptive of a lot of Republicans and conservatives' ideological priors when it comes to regulation. I one time always believed, more strictly than I do now, but still mostly believe, that market solutions are the best solutions. It's best for individuals to make small decisions in the marketplace for the most efficient distribution of goods. However, recent events, I think, have made it inarguable that the large internet platforms are not acting as simple wealth maximizers that we all learned about in Econ 101, but rather have taken a political slant, a political motivation, and furthering an ideology which is at odds with what a lot of conservatives and Republicans believe. And I would point, evidence for the prosecution, if anyone doubts that, the suppression of the Hunter Biden stories at a pivotal moment in the 2020 election, the continued censorship of legitimate scientific inquiry about public policy responses to the COVID epidemic. And it continues in a variety of different ways that are less noticeable in the news. So for instance, we just learned that anyone who questions the climate change consensus is now spreading disinformation. So on a variety of different levels, it appears as if many of the platforms are acting in ways that aren't consistent with what we'd expect from regular wealth maximizing entities, and are behaving in ways that actually could threaten something perhaps even more important, which are our democratic institutions of free speech, and the potential for impartial government, that we really need to preserve those markets and to make sure that we have fair decision making. So that has led me, and I think many other Republicans, to the belief that yes, something must be done to respond to the power of this large internet platforms, in particular the social media firms. I would say, just as a side note, I think the hypocrisy is much worse on the left. If you read Jon Stuart on the liberal left, or you read John Stuart Mill, he's as hard on private censorship as he is on government censorship, but that's forgotten now by the left. They're fine with Facebook and Google censoring people on our side. So I think, as far as intellectual inconsistency, we're not really there. I think we're fighting to try to preserve the institution of free speech in a medium which does not seem particularly respectful of it. So what are some of the approaches that we can do? Well, I think there are four I'll touch briefly on today. One, innovation. Two, removing some of the privileges that the big platforms enjoy, largely because of historical accident, but most notably under Section 230, the possibility of antitrust, new legislation, or existing enforcement. And finally, the wagon to which I'm hitching my star, which is state laws to prohibit discrimination by social media firms, and in particular the one passed by the state of Texas, currently under appeal before the Fifth Circuit, which I think offers a model to the nation, and which I hope and pray the Fifth Circuit will uphold. So let's start with the first response, innovation. And of course, we hear it all the time. You don't like the way Facebook edits your posts. You don't like what Google does to your search rankings. Build your own Google. And of course, the implicit little assumption is that Google isn't there because of accents or government preferences. It's because the left is smarter, and you silly, not so bright right wingers, you can't possibly do it. Well, certainly Parler tried. In January 2021, it was the most downloaded app in the world, and it was being downloaded at an incredible rate, one that was actually threatening to many of the platforms. But magically, what happened when there seemed to be an opposing ideological company? Well, Amazon, at the behest of certain Democratic politicians, it appears, of course, as we all know, the web services took the Parler servers away, essentially threw them offline, really destroying the momentum for that company, which is now trying to recover. And that this further links to Parler were blocked from the major social media companies. So if we're serious as Republicans, as conservatives, as creating an alternative, we have a problem. There is an entrenched network effect that is going to be working against us. Okay, so let's talk about removing some of their privileges. Certainly Section 230, which was designed for the dial-up internet, which when you had a telephone and you had to use their modem and match the protocols, and as I tell my students, it was used in Western civilization about a few years after we stopped putting cuneiform lettering into clay tablets. I usually get a joke on this. It's very, very hard, tough crowd. So it was really designed for a world in which there were walled gardens, and the idea was that to encourage more conversation, to encourage more diversity and free speech, we would limit the liability of the platform, so they wouldn't be liable for every comment that was made on their bulletin boards. However, what it has become is it has become a legal shield for the platforms to impose their censorship regimes. And so they can't be challenged under anti-discrimination laws, they can't be challenged under consumer fraud laws, they can't be challenged under contract. So if we're interested in free speech, these have to be pushed back. One way is the courts to try to get rid of some of these entrenched rulings. I was once involved in a case doing that, one of the few, I think the only one to ever win at any level on a sort of free speech grounds. And when we did, essentially all of Silicon Valley marshaled its troops. We had as interveners Facebook, Google, Twitter, and every 3 internet associations, and of course it was reversed on this extraordinary procedural reaction, and we didn't even have a chance to argue it before a judge. The response was so sudden, so quick, and that has been our experience in other situations too. We're very much outgunned from a litigation perspective. So of course there's reform in Congress. So there's been a lot of very good statutory reform. In particular, I think Senator Hagerty from Tennessee has done a great job. But given the current political constellation, it's unlikely whether any of these nice reforms will ever get passed. They're still very much in the idea stage. Okay, so that leads us to antitrust. Again, the Justice Department under President Trump did file a landmark suit against Google. and it's languishing, as all the several other court antitrust actions against Google. They've gotten a lot of setbacks. This has to do, I think, complex reasons about antitrust law, which makes it particularly difficult to win these suits against the platforms due to the nature of the markets that they dominate in. So that leads to some type of reform. And actually, there's been a lot of movement on the Hill introducing several interesting bipartisan antitrust reform bills. However, the phrase is, beware Greeks bearing gifts, and I think the same thing could be said about Senator Amy Klobuchar. Many of these bills come with strings that may not be too friendly toward conservative free speech, and we have to be very, very careful about that. And so they may increase the potential for antitrust liability, but they often will end up, as a result, giving these platforms even greater power to censor. And so there we go with antitrust. It's unlikely that the Biden administration will bring any huge, useful antitrust lawsuit. And once again, it's unlikely that Congress will come up with any great idea given the current political constellation. So what's left? Well, all eyes turn to Texas. The states have been remarkably active in passing anti-viewpoint discrimination statutes. So what does this mean? Well, for centuries, certain basic industries and technologies, ranging from the stagecoach and the railroad to the telephone and the telegraph, were under the obligation to serve all customers without discrimination. Just a basic rule of American industrial structure that it was considered, and perhaps correctly so, I believe so, that there's just certain industries where consumers should not be at the arbitrary mercy or whim of the provider, and they have a right to use their services without discrimination. And to this day, telephones, local telephone services still regulated in the same way. Airlines are, FedEx deliveries are. FedEx can't refuse to deliver you because you're Episcopalian or because you're Jewish or because you're Black. You have a right to get on an airplane regardless of your political point of view. And what these statutes do is the same thing holds for social media. They can't discriminate in the viewpoint discriminate or discriminate on the basis of your political or social views in the provision of social media services. So the first state to pass a similar type of law was Florida. This was a little different. It wasn't a sort of common carrier law that protected citizens. It was more of a protection of political candidates and journalists, oddly enough, and that was challenged in the 11th. It was thrown out by a Democratic-appointed district judge, and is now before the 11th Circuit. I think a far better model was Texas's model, which is a common carrier approach, and simply says, social media companies, you can't discriminate on the basis of viewpoint. That means you can't, in your deplatforming decisions, in your promotion of content, you can't treat people who are essentially similarly situated but only differ because of their political beliefs in blatantly discriminatory ways. And it was, of course, challenged by a phalanx of leading lights in the big tech industry, and we had I don't know if I should say this, we had the luck of getting Judge Pittman, who was not particularly, again, another Democratic appointee who was not particularly friendly toward the bill, the law, I should say. However, that too is currently under appeal to the Fifth Circuit. So that's sort of the state of the play when it comes to sort of conservative Republican reaction to big tech. Delighted to answer questions. Again, I think it's a really sort of turning point, not just from a policy perspective, but also from a ideological or sort of values perspective. I think if we're going to go down this route, we have to recognize that in a small minority of situations, the market may not have the right answer, and that there are certain institutions like free speech like the full participation of all citizens in political discussion, that require us to take a closer look. So delighted to answer any questions. Thank you so much.